Welcome to our continuing 2018 educational webinar series. I am Catherine Short, Partnership Marketing Specialist for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Trey Scott, Associate Attorney at Kennedy Attorneys and Counselors at Law, a health law boutique in Dallas, Texas. He received his Bachelor of Science and MBA from Texas Tech University at Lubbock. Trey received his JD degree from Texas Wesleyan University School of Law in 2012. During law school, he was a member of the Student Bar Association, serving as the social chair and 3L representative. Mr. Scott also interned with the 106th District Court of Texas in La Mesa, Texas in 2010. In private practice, he has worked with medical practitioners on meaningful use appeals, matters involving the National Practitioner Data Bank, Medicare, Medicaid investigations, wage and hour lawsuits, contract litigation, payer post-payment audits and appeals, government surveys, appeal, and compliance. Mr. Scott is licensed in Texas and currently focuses his practice on health law and healthcare regulatory compliance, as well as administrative law and civil litigation. Since joining Kennedy in 2015, he has assisted clients in civil and administrative litigation, payment and reimbursement appeals, and professional licensing boards, regulatory licensure, filing and compliance, fraud and abuse defense, employment law, transactional issues, and other provider matters. A copy of the slide deck is available for download on the control panel. Feel free to submit questions in the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your Paycom CEU certificate will be emailed to you from Paycom following the broadcast. There is no need to request it. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. Trey, go ahead.
Thank you for the introduction, Ms. Short, and thank you for joining the webinar today. It is a great pleasure to get to speak with all of you about the Medicare Part A and Part B appeals. Now, the title of my presentation is Money Talks, Medicare Part A and Part B Appeals. Now, when you hear Money Talks by AC/DC, what comes to mind? Now, there's a story behind the song Money Talks. Whenever I was growing up, I had older siblings, and this was during the 80s and 90s, and the music that they listened to was rock. They listened to AC/DC, they listened to Metallica, Van Halen. So majority of my memories of music from that time are rock songs by those artists that I just mentioned. My parents listened to country music, but I was introduced to rock by my siblings. So whenever I was putting together the presentation, Money Talks seemed to be the appropriate title based on what we're going to discuss here. But now you know what comes to mind whenever I hear the song. But what comes to mind whenever you hear the song? Is it hair metal, the glory days of bands with lots and lots of hair and hairspray? Is it because of the catchy lyrics in the song Money Talks? Maybe it's because the lyrics sound a little dated based on everything that's going on in culture today, or who knows? It could even be your favorite song. I will admit, out of AC/DC and their vast collection of songs, Money Talks is actually a song that I tend to play more than any other AC/DC song. Isn't my favorite one? Not necessarily, but somehow it manages to get played more than others. Now let's go back to why Money Talks. Throughout this presentation, you are going to see a daunting appeals process for appealing Medicare Part A and Part B claims. You're also going to understand what happens whenever a review/audit is done of previously paid claims, and that sample audit is then extrapolated over a universe of 2 years. And the result is going to be a situation where the provider is left owing a lot of money. So it seems appropriate, because whenever it comes to Medicare Part A and Part B appeals, money talks. So that's the reason for the song. Now, as Catherine mentioned, I am an associate attorney at Kennedy Attorneys and Counselors at Law. I have a lot of experience in overpayment matters. As a matter of fact, the first case I worked on whenever I joined Kennedy Attorneys and Counselors at Law was a $6.2 million overpayment that went through the Medicare Part A and Part B appeals. I also have assisted providers in Department of Justice / Office of Inspector General investigations and document productions. I've assisted providers in revocations and suspensions, and also a lot of HIPAA breaches. We have had our fair share of dealing with providers that deal with HIPAA breaches. Then there's meaningful use. Medical malpractice, not as prevalent in the state of Texas where I practice due to tort caps, but still an area that we have cases on, and then matters before medical boards. Now, just to give you a roadmap of where we are going today, first of all, we're going to talk about the stages of the appeals. The process is a 5-stage appeals process. We're also going to talk about various issues throughout the appeal process, because there are issues that for the providers that are not aware of these issues, it can be very frustrating and also cause significant delays. And then finally, I'm going to leave you with some final thoughts on what the appeal process is. I've kind of tipped my hand already by stating that I said it was a daunting process. So that's the roadmap today, and let's get started with the appeal process. Now, the first stage in the appeals process is what's known as an initial determination, and you can find information regarding initial determinations from 42 C.F.R. sections 405.920 through 405.928. And just to let you know, C.F.R. stands for the Code of Federal Regulations. Now, the Code of Federal Regulations is different than statutory authority. The Code of Federal Regulations is essentially what governmental agencies use as guidelines, as regulations. These are the regulations / red tape that people deal with when dealing with governmental agencies. And as you all know, HHS, or Health and Human Services, is a governmental agency, and within Health and Human Services, there's CMS, the Centers for Medicare and Medicaid Services. So that's the governmental agency we are dealing with, and the regulations we are looking at. Now, an initial determination, this is a determination as to whether a claim should be paid or whether the claim should be denied. This is performed at the MAC level, which is the Medicare contractor that is Medicare administrative contractor that deals with the area that you are in. For example, in Texas, if you're a home health agency, more than likely you are dealing with Palmetto. If you are a EMS provider, you are dealing with Novitas. Now, after a determination is made, then notice is sent regarding that determination. And the notice is going to let you know whether the claim is approved or whether the claim is denied. Now, you can appeal initial determinations. This is what starts the appeal process. The denial or approval starts the appeal process. Now, previously paid claims can be reopened pursuant to 42 C.F.R. 405.986. Now, what this means is all of the claims that you previously submitted that were paid can be reopened if good cause exists. Now, what determines good cause? That is essentially up to the UPIC. Now, UPIC stands for Unified Program Integrity Contractors. These are contractors that investigate fraud, waste, and abuse. In Texas, the UPIC is Clarent. That's QLARANT. The contractor used to be Health Integrity, and it was a ZPIC, or Zone Program Integrity Contractor. However, Health Integrity dissolved and became Clarent. Now, what the UPICs do is they send a letter to providers requesting a sample. They want 30 records because they have essentially found that there was new evidence that suggests that the claim may or may not should have been paid. So they request a sample. Now, that sample is anywhere from 25 to 50 to 60 records. After they receive these records, they review them and determine whether they should be paid or not, and then they determine an error rate out of those claims. The error rate can vary between 70 to 95%, some cases 100%. What the UPIC then does is extrapolates that error rate over a period of 2 to 3 years, over a universe of claims that are exactly or very similar to the claims that were sampled. That is how you end up with the $6 million overpayment, the $12 million, the $400,000 is because of statistical sampling and extrapolation. So those determinations are worth your time to appeal because money talks. And that's money that unfortunately you were already paid, or the provider was already paid. So in the government's or CMS's eyes, that's money that is owed back to CMS. So they send a request for they send notice that the determination was made, and then they request payment. Well, after you receive that determination, you can go to the first stage of the appeal, which is known as a redetermination. A redetermination, regulations for redetermination can be found in 42 C.F.R. sections 405.940 to 405.958. Now, the appeal must be filed within 120 days from the date of receipt of notice. Now, going back to the previous slide, I said that notice sent regarding the determination. Once that notice is sent and received, that's whenever you're able to appeal. Now, it is assumed you received the notice within 5 days of the date on the notice. Now, do you really receive it within 5 days? It depends. The government says it's assumed you receive it within 5 days, and if you received it after the 5 days, then you need to have proof that you received it after the 5 days. And since a lot of these are not sent via FedEx or other means, it's somewhat hard to prove that it was received after the 5 days. So in our office, the standard procedure is we just appeal based on the date on the notice. It gives you time to make sure you get it in. Now, you have 120 days, but recoupment starts at day 40. Now, recoupment is all money that you should be receiving for claims that were sent in. It is recouped. It's taken back. You're not given that money. So say you have $20,000 in claims that you're awaiting to receive from Palmetto, but you have a $400,000 overpayment. At day 40, if you have not filed an appeal, the Palmetto is going to take that $20,000 and apply it against the debt, against the $400,000. Now that gets very, very complicated because you should have 120 days, but in essence you really don't. So if you want to avoid recoupment, you file at day 40, and recoupment stops whenever the appeal is filed. I should say recoupment stops when the appeal is processed, and it could take some time for the appeal to be processed at the first level. Now, your redetermination is sent to the Medicare administrative contractor that is listed on the notice letter. The notice letter provides you who you need to send the redetermination to. Now, the redetermination request must state why you disagree with the determination and should include all supporting evidence. A decision should be issued within 60 days, but that can vary. It's extended every 14 days, or it's extended 14 days every time you supplement with additional evidence. Now, one good benefit of supplementing with new evidence is you continue preventing recoupment from occurring. However, you are charged interest on the debt, and I believe the interest is upwards of 9%. I'm not sure the exact amount of interest at the current time, but it is a substantial amount. Now, the next stage of the appeal is a reconsideration, and a reconsideration occurs after you receive a redetermination decision. The Medicare appeals contractor reviews everything that you submitted and determines that your redetermination was either favorable, partially favorable, or unfavorable. And the reason that can occur is you are appealing, in some situations you are appealing multiple claims, and you're appealing the statistical sampling that I mentioned earlier in this presentation. So there are multiple parts to an appeal unless you are appealing one claim. So that's why it could be favorable, partially favorable, or unfavorable. Now, the reconsideration, it must be filed 180 days from the date of receipt of decision. Again, the same 5-day assumption And at this stage, you are protected a little bit longer from recoupment. You are protected for 60 days after the decision. So in this case, we recommend filing on day 45. The reason we recommend filing on day 45 is it could take some time for the contractor that you send your reconsideration to. It could take them up to 2 weeks or 10 business days to log the reconsideration into the system. So you don't want recoupment to start on day 60. Now, a reconsideration is to be filed with the qualified independent contractor for your region. And in the case of Texas, the quick is C2C, and that's where the reconsideration is filed. The request for reconsideration must include evidence, facts, and/or law related to the disagreement, and any evidence you have should be submitted at this stage, because there are regulations out there stating that evidence submitted after the quick decision, after the reconsideration decision, can be barred. We'll discuss that a little bit later on in the presentation, but it is recommended that you submit your evidence at this stage, no later than this stage. A decision on your request for reconsideration should occur within 90 days. That can be extended based on the additional submission of evidence, or if it just takes longer than 60 days for the quick to issue a decision. If it's going to take longer than 60 days, the quick normally sends you a letter informing you that it's not going to be processed in the 60 days and provides you with options on what to do if it's not going to be processed in the 60 days. We'll discuss that later on in the presentation. Now, the third level is the ALJ hearing stage, the ALJ stage. This stage occurs after reconsideration, after a reconsideration decision is issued. There are a lot of regulations regarding ALJ hearings. The regulations for ALJ hearings can be found at 42 C.F.R. sections 405.1000-405.1058. So there's a lot of regulations out there. The request for ALJ hearing must be filed within 60 days of the reconsideration decision. Again, you have the 5-day assumption. Now here, this is where it gets interesting regarding recoupment. Now, at the reconsideration stage, once your request for reconsideration is filed, recoupment stops. It's the same as the redetermination stage. However, once you get to the ALJ stage, recoupment does not cease. It starts on day 31 after you have received your reconsideration decision and continues. It could vary because if you prevailed at either the redetermination stage or the reconsideration stage, the Medicare administrative contractor issues a recalculation. And if you had a favorable or a partially favorable decision, the amount is recalculated, and recoupment begins 30 days after receipt of the recalculation. So there is some variance on that. However, the safest thing to assume is that reconsideration is going to begin on day 31 after the decision. Like I stated in the previous slide, all new evidence is most likely barred from being admitted unless you can show good cause. Now, good cause, it really varies. It could be serious illness prevented the submission of the evidence, possibly. These are just ways to state that it could possibly be good cause. So the safest thing to do is to submit all evidence before you get to this stage. The request for ALJ hearing must state the reasons for disagreement with the reconsideration decision. These disagreements can be, again, facts, evidence, or law as to why you disagree. Now, at the ALJ stage, unless you waive, because there are ways to waive a hearing, and most of the ways to waive a hearing involve actually stating to the ALJ that you do not want a hearing. You just want a decision on the submissions, which means an ALJ decides the case based on your written submissions. But the hearing is open to parties and to other persons the ALJ considers necessary and proper. In this case, who the ALJ most likely considers necessary and proper, that is the UPIC, because they determine the statistical sampling, if it's a case involving statistical sampling, and the the Office of General Counsel for CMS. They're the CMS attorneys. At this stage, the ALJ examines issues, questions parties, and may limit testimony. It depends on the ALJ's view as to whether testimony is appropriate or also just time frames. The hearing can be continued in 2 parts. This occurs whenever you have multiple witnesses that are going to be testifying, and also it is a case where there are multiple claims at issue. An example would be a $400,000 overpayment where you're challenging the statistical sampling, and whenever you have someone that is testifying as to why the individual claims are or should be approved. So you have a statistical sampling expert, you have a medical records expert, you also have a nurse administrator that treated the patients. That's how a hearing can be continued in multiple parts, because Clarent, or the UPIC, will also have someone come in and testify stating that the statistical sampling they conducted was appropriate. Now, the decision from an ALJ should occur within 90 days from date request is filed. This is not currently the case, unfortunately. ALJ appeals, according to the American Health Lawyer Association, I believe this was in February or March of this year, they said that ALJ appeals can take more than 1,100 days. That is a very, very long time for a decision, or to wait for a decision. The ALJ can decide that all the claims should be approved, the statistical sampling can be thrown out. The ALJ can also remand the decision to the QIC, or the qualified independent contractor, and say you messed up, fix something. So there are a lot more options at this stage than previously. After the ALJ issues its decision, we go to the Medicare Appeals Council, and this is a request for Medicare Appeals Council review. The regulations for the Medicare Appeals Council review can be found at 42 C.F.R. sections 405, 1100 through 405, 1140. Now, the MAC review time frame identical to that of the filing a request for ALJ. It's 60 days, and there is the same assumption of 5 days. The MAC, the Medicare Appeals Council, its request must identify parts of the ALJ's decision that the appellant disagrees with and why. Previously, you could essentially file a request for ALJ hearing and just say, I disagree based on the reconsideration decision, and here's why. You could just say, I disagree, and they messed up. You're more than likely not going to prevail, but the ALJ reviews everything and conducts their own investigation, and they can issue a determination and says, well, yes, he disagreed, but he is correct. It's wrong. At the MAC level, you cannot do that. You must identify specific parts of the ALJ's decision that you disagree with and explain why you disagree with them, and it needs to be detailed. Say the ALJ approved the statistical sampling even though the expert testified that it was flawed in this way. You can bring that up and say, I disagree with the ALJ's decision because my expert testified to this, and this, and the ALJ did not give enough deference to my expert. That is how this appeal would occur. A decision must be issued by the 90th day, similar to the ALJ. Now, the council may adopt, modify, or reverse the ALJ, and they can also remand the case to the ALJ. Very, very similar to the ALJ. Now, here, after MAC review, there is one more stage. Now, this is judicial review. So, after the MAC issues its decision, by the 60th day, if you disagree with the MAC decision, say it adopted the ALJ's decision and the ALJ did not find anything in your favor and you want to go to another stage, you file a lawsuit for judicial review in the federal district court where the provider resides. So, for example, just to give an example of my area, we have a provider in Dallas that receives a MAC decision that it disagrees with and wants to file a request for judicial review. The case would be filed in the Northern District of Texas. And it should be pointed out that since this is a federal matter, since you were dealing with CMS, and this is a federal matter, the judicial review must be filed in federal court. Just wanted to point that out there. Now let's talk about some issues in the appeals process. I've named a couple as we went through, but there are others. Evidence bar. This is a very big issue because it can make or break your case. say you found something, and unfortunately you didn't have the opportunity to submit it at the redetermination or reconsideration stage. You can state why it was not submitted at one of those stages, but the ALJ can rule as to whether it should be admitted or not. And if that evidence is barred, it's very, very difficult after that. An example of this would be you want to retain a medical records expert to review your records and provide summaries as to why each individual claim should be approved. You want to include that with your request for reconsideration. Unfortunately, your expert takes too long and that evidence is not able to be submitted. Those written statements are not able to be submitted. You can try to get them admitted at the ALJ stage. You can say, well, this is just written testimony and it was not available because my expert took too long or my expert had some sort of delay. That may or may not be admitted. It honestly depends on the ALJ that you get in this case. If the ALJ decides that evidence is barred, you can object and raise the issue with the MAC. Now, remember, whenever I stated that, you can identify parts of the ALJ's decision that the appellant disagrees with and why. That could be one of the reasons you disagree with the decisions, that this evidence was not allowed, and you can raise the issue with the MAC. And it would be up to the MAC to determine whether or not the ALJ was correct in allowing the evidence to be barred or not. The next issue in the appeals process is the delay. Now, cases at the ALJ level can take years due to the volume. According to HHS, there will be an estimated 1 million appeals at the ALJ level by 2021. 1 million appeals that ALJs have to work through. Now, in September of 2017, there were an estimated 594,000. So, according to HHS, they believe that the backlog is just going to continue because more and more appeals are being submitted than what ALJs can actually go through. So this leads to a substantial backlog. And the unfortunate part of a delay is that, remember, you are being recouped at this stage. So something that should take 90 days, but actually takes 1,100 days, and you're being recouped during that whole time. If it's a $400,000 overpayment, then you've probably almost paid that back. Or if you haven't paid it back, you end up going out of business, which is not good for, obviously, your employees or the patients that you're treating. This is a very, very serious issue. It's increased from February 2014 because in February 2014, the wait to even be assigned to an ALJ was 28 months. It has increased by some time. Now, another issue is it's not only limited to the ALJ level. Delays can occur at each stage, but at the redetermination and reconsideration stage, if there's a delay, it doesn't hurt you other than the accruing of interest. But at the ALJ and MAC level, it does hurt due to the recoupment. We represent a provider currently that sat at the MAC for over 1,500 days. It's unfortunately that provider is now out of business. They closed their doors, and we are going through a lawsuit based on the delay. But delays do happen, and unfortunately, the delays can be very harmful. Now, there are options to avoid the delay. The regulations provide for an opportunity to escalate to a new level if it's taking too long. If your case is sat at the reconsideration, the ALJ, the MAC level, if a case is sat there longer than the appropriate time for a decision to be made, then you can escalate to the next level. An example, say your case is at the ALJ level, it's sat there for 90 days, and you don't have a decision yet. You're like, well, this is taking way too long. I need to be heard because I'm about to go out of business. So you request to escalate. That takes it from the ALJ level to the MAC level. Essentially, the request to escalate states that the ALJ has to issue a decision within 5 days. If not, you go to the next level. There are pros to this. The pro is obviously that your case gets heard instead of sitting there for 1,100 plus days. The negative drawback is you lose the opportunity to prevail at the skipped level. So if you're sitting at the ALJ level and you go directly to the MAC, you lose the chance of potentially prevailing at the ALJ level. You've essentially knocked a 5-stage administrative appeal process down to a 4-stage. And I say 5-stage because of the redetermination, reconsideration, ALJ, MAC review, and judicial review. Another option to avoid the delay is a lawsuit. Now, I've listed 2 cases. The first case, even though it's listed at the bottom, this case happened first. It's a 2016, I believe, 2016 case decision. It's American Hospital Association v. Burwell. It can be found at 812 F.3D 183, and this is out of the D.C. Circuit. What this case essentially stated was that delays are taking too long and providers should not be forced to escalate. Essentially, it's telling CMS, clean up the backlog of cases. Now, CMS is working to do that because they do have some special initiatives that are occurring at the ALJ level, which you may or may not qualify for. That can be found at the Office of Medicare Hearings, and it's OMHA. It's OMHA. They can be found at that site. The next lawsuit is one that actually happened at the Fifth Circuit. This is Family Rehab v. Azar. It's 886 F.3D 496. And this case, the Fifth Circuit said that the lower court messed up in not allowing for Family Rehab to receive an injunction preventing recoupment. Now, just some facts. This case involved a over $7 million overpayment, and It had gone from the redetermination to reconsideration level, and a reconsideration was decided. Then they filed a request for ALJ. However, the request for ALJ was not being heard, and the court had some interesting language. It said, and this is on, excuse me, this is on page 500 of the decision. It says, yet an ALJ hearing is not forthcoming, not within 90 days and not within 900 days. According to Family Rehab, and effectively conceded by the government, it will be unable to obtain an ALJ hearing for at least another 3 to 5 years. And based on HHS's own admissions to a federal judge, the logjam of Medicare appeals shows no signs of abating anytime soon. Thus, the earliest Family Rehab could complete administrative review through escalation, which could be as late as July 24, 2018, or 270 days after they filed their request for ALJ hearing. Now, the court was essentially saying this is ridiculous, and was saying that the lower court should have granted the injunction to Family Rehab because of the delay. And this is something that if providers are able, if they find themselves at the ALJ level and they do have appropriate funds, this is something that we recommend seeking an injunction because due to the delay of cases. Now, some final thoughts. Final thoughts on this process. It is extremely daunting. There are a lot of regulations, and I'm going to show you real quick. This is all the regulations regarding the appeals process. It starts at 405-900 and just goes through. It's a lot of regulations to know what you need to have in the administrative appeals process in the various stages, what can be submitted, what can't be submitted, whether discovery is allowed, the process and effect of a remand. It goes all the way to the Medicare Appeals Council review, and then talks about judicial review. It is a very, very convoluted process that providers have to go through, and it's very daunting. The appeals process can be long and costly because if you just go through a regular process and you end up having everything go your way, decisions are issued within 60 days, and everything goes your way, it still is very long and still can be very, very costly. But you end up running into situations where the appeals process takes longer. It can take 7 years. It can take even longer than that. It's very, very, very daunting and costly. As stated, there's multiple requirements for each level under the regulations. And finally, the worst thing about the appeals process, recoupment begins. So if it is a post-pay review and a claim has already been paid, there's a good chance if you don't prevail at the first two levels that money is going to be paid back just due to the delay. So that even makes it more costly for the provider. And with that, we now turn to questions. And I'm looking forward to hearing what y'all may have had come up during the presentation.
Okay, Trey, this is Catherine. So we did have a few questions come in. So one of the questions was, what are the most important stages that you might have there?
In the appeals process, the most important stages obviously are the redetermination and the reconsideration stage. You need to put everything you have into those two stages to try to prevail due to the backlog at the ALJ level. If you prevail at those two stages, and if it's an extrapolation and you knock the extrapolation out, that really reduces your overpayment, then that it's not going to be as much of a burden to be recouped at the ALJ level. If you don't prevail, then like I said, you end up in that situation where you're being recouped on a very large amount. So the first two stages are the absolute most important.
Okay, good. So another question we had come in was, what happens after a judge issues a decision at the judicial review stage?
This is a very good question. After a judge issues a decision at the judicial review level, you go through the normal judicial appeals process. You can appeal to the fifth, or you can appeal to the you can appeal to the Circuit Court of Appeals for the circuit that you are in. For example, like I said, Texas is the Fifth Circuit. So that example I used of the Dallas provider, say the Dallas provider gets a decision from the Northern District that is unfavorable, and they decide to take it up to the Fifth Circuit. The Fifth Circuit would review, ultimately determine whether or not to hear it, and then they would issue a decision. And after that, depending on the situation, you could even appeal to the Supreme Court of the United States. So the appeal doesn't die after the judicial review level. It unfortunately just ends up in litigation and can get costly.
Okay, and then so do you recommend escalation? That's another question we had.
Do I recommend escalation? Based on everything I've seen, I do not recommend escalation. The benefit of it, like I said, is that your case actually gets heard. However, you lose the opportunity to prevail, and that is such a big thing, because for the phrase bites at the apple, you are essentially removing a bite at the apple, an opportunity to prevail each time you escalate. And with the lawsuits out there and the recent case decisions, I would recommend filing the injunction and potentially having the injunction issued and preventing recoupment. That would prevent the reason for why you would want to escalate, because losing that opportunity is not something you want to do.
Okay, good advice. All right, I think we're running a little bit over time, so I think that we had a few other questions, but I think I'm going to take those offline, and we'll just take those into email. So if we had other questions, you're going to get those attendees addressed directly. So Trey, I wanted to thank you. Do you have a contact slide there?
I do, yes. Thank you very much for giving me the opportunity. And if you have any questions after the fact that you did not submit, just contact me directly. My email is trey@markkennedylaw.com. That's MarkKennedylaw.com.
Perfect. Perfect. And if for some reason you weren't able to get that there, or if you think of something later, you can contact us here at First Healthcare. And so my contact will be up there in just a minute, which is communications at 1sthcc.com. You can also register for future webinars or request a demo of our compliance solution on our website, which is firsthcc.com. You can also call us at 888-543-4778. Did you have any final thoughts at all, Trey?
Just thank you for the opportunity. And again, if you have any questions that come up after the fact, feel free to shoot me an email, and I'll do the best I can to answer the question.
Okay, great. Great. Well, we thank you so much. We're very appreciative. I know I'm so grateful for you presenting this. A lot of really, really great information and very interesting. So thank you so much. And attendees, I wanted to thank you so much for joining us also. So thank you.
Thank you.